1. Alright, let's make sure that's working. 1. Test, test, test. Test, test, test. Test, test, test. Is that working? Test, test, test. Is that working? Test, test, test. Okay. Test, test, test. There we go. Boop, 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 boop. Looks like it's working. Boop, 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 boop. Looks like it's working. All right. I'm getting pretty deep into this. I almost regret committing to doing every single one of these. It's taking me a lot longer than I thought it was, but committing to doing we're gonna do it. And today I think we're getting into 47. I'm gonna try to get through 50 at least. Try to get through number 50. And all these are gonna be on the separation of powers. This is gonna be, I think, all Madison. This is gonna be all Madison. And he's going into like the separation of powers, and I think when we get to 50, he's gonna start talking about like what should you do when someone violates the Constitution? Like, what are the mechanisms? All right. 47, Federalist, James Madison. Again, he's writing, these are going like into little pamphlets. He's writing to people to try to get them, convince them to ratify the Constitution. This is so post-revolution, pre-Constitution, they're writing these. Trying to get the people on board with the Constitution, trying to get the states to ratify it. Having reviewed the general form of the proposed government and general mass of power allotted to it, I proceed to examine the particular structure of this government and distribute of the mass of power among the constitutionate parts. 1. Principle of objections included in the mere respectable advisories to the Constitution. It is a supposed violation of the political maxim that the legislative, executive, and judiciary departments ought to be separate and distinct. So this whole one is going to be about the separation of powers into the three branches and the balance between the three branches. In the structure of the federal government, no regard, it is said, seems to have been paid to this essential precaution in the favor of liberty. The several departments of power are distributed and blended in such a manner as to once to destroy all symmetry and beauty of form, and to expose some of the essential parts of the edifice to the danger of being crushed by the disproportionate weight of all other parts. No political truth is certainly of a greater intrinsic value, or is stamped with the authority of more enlightened patrons of liberty than that on which the objection is founded. Alright, so he's preambling about separation of powers, and now he's going to get into his argument. The accumulation of powers, legislative, executive, and judiciary, in the same hands, whether of one, a few, or many, and whether hereditary, self-appointed, or elected, may justly be pronounced in the very definition of tyranny. Were the federal constitution, therefore, really chargeable with the accumulation of power, or with the mixture of powers having a dangerous tendency to such an accumulation, no further arguments would be necessary to inspire a universal reprobation of the system. I persuaded myself, however, that it will be made apparent to every one that the charge cannot be supported, and that the maxim of which it relies on has totally misconceived and misapplied. So, Madison is a big fan of this. James Madison was an interesting fellow. Yeah, he was a very interesting fellow. He's a lot harder to read than Hamilton, because James Madison just likes to write in giant singular paragraphs and doesn't separate his ideas. So it's like you're like reading, you're like, all right, my eyes need a break, but can't. All right, so he's getting in, he's bringing up the objections. And so Madison does this a lot. He'll bring up the objections to this part of the Constitution, and then he'll try to like go through each of their arguments. He likes to steel man the other side's arguments, and then try to break them down. In order to form a correct idea on this important subject, it will be proper to investigate the sense in which the preservation of liberty requires that the three great departments of power should be separate and distinct. The oracle who is always consulted and cited on this subject is to be celebrated Montesquieu. If he is not to be the author of this invaluable precept in the science of politics, he has the merit at least of displaying and recommending its most effectively to the attention of mankind. Let us endeavor, in the first place, to ascertain the meaning on this point. The British Constitution was to Montague what Homer has been to the didactic writers of epic poetry, and the latter have considered the work of immortal bard as the perfect model from which the principles and rules of the epic art are to be drawn, and to which all similar works were to be judged. So the great political critique appears to have viewed the Constitution of England as the standard, or to use his own expression, as the mirror of political liberty, and to have delivered the form of elementary truths, the several characteristic principles of that particular system. All right, so he's going to use Montague as kind of a authority figure in his argument. All right. That we be sure then not to mistake his meaning in this case, let us recur to the source from which the maximum was drawn. On the slightest view of the British Constitution, we must perceive that the legislative, executive, and judiciary departments are by no means totally separate or distinct from each other. The executive magistrate forms an integral part of the legislative authority. He alone has the prerogative of making treaties with foreign sovereigns, when made have under certain limitations the forces of legislative acts. All the members of the judiciary departments are appointed by him, can be removed by him on the address of the two houses of Parliament, and form, when he pleases to consult them, one of the constitutional councils. One branch of the legislative department forms also a great constitutional council on the executive chief, as on the other hand it is sole depositary of the judiciary power in cases of impeachment, and invested with the supreme applicate jurisdiction in all other cases. The judges, again, are so far connected from the legislative department as to attend and participate in its deliberations, though not admitted to the legislative vote. From these facts by which Montesquieu was guided, it may clearly be inferred that in saying there can only be no liberty where the legislative and executive powers are united in the same person, or the body of magistrates, or if the power be judging not to be separated from the legislative and executive powers. He did not mean these departments ought to have no partial agency in or control over the others, the acts of each other. His meaning is in his own words import, and still more conclusively, as illustrated by the examples in his eye, can amount to no more than this, that where the whole power of one department is exercised by the same hands, which possesses the whole power of another department, the fundamental principles of free constitution are subverted. This would have been the case in the constitution examined by him, if the king, who has the sole executive magistrate, had possessed also the complete legislative power, or the supreme administration of justice, or the entire legislative body had possessed the supreme judiciary, or the supreme executive authority. This, however, is not among the vices of that constitution. The magistrate in whom the whole executive power resides cannot himself make laws, though he can put a negative on every law, nor administer justice in person, though he has appointed of those who do administer it. The judges can exercise with the legislative councils. The entire legislative can perform no judiciary act, though by joint act of the two branches, the judges may be removed from their offices, and though one of these branches is possessed of judicial power in the last resort. The entire legislative again exercises no executive prerogative, though one of its branches consults the supreme executive magistrate and the other on the impeachment of the third. All right, hold on one second. One of its branches consults the supreme executive magistrate and the other on the impeachment of the third. All right, hold on one second. Can try and condemn the subordinate officers in which the executive department. The reasons on which Montesquieu grounds this maxim are further demonstrated of his meaning. When the legislative and executive powers are united in the same person or body, says he, there can be no liberty, because apprehensions may arise, the same monarch or senate should enact tyrannical laws to execute them in a tyrannical manner. Again, were the power of judging joins the legislative, the life and liberty of the subject would be exposed to arbitrary control, for the judge would be the legislator. All right, so he's getting real deep into Montesquieu. He's trying to use him as an authority on this subject. I guess Montesquieu was probably really influential around this time. I mean, I guess he still is. Were it joined to the executive power, the judge might behave with all violence of an oppressor. Some of these reasons are more fully explained in other passages, but briefly stated as they are here, they sufficiently establish the meaning which we have put on the celebrated maximum of a celebrated author. If we look at the constitutions of the several states, we find that, notwithstanding the emphatical and in some instances the unqualified terms in which this axiom has been laid down, there is not a single instance in which the several departments of power have been kept absolutely separate and distinct. New Hampshire's, whose constitution was the last formed, since has been fully aware of the impossibility and inexpediency of avoiding any mixture whatever of these departments, and has qualified the doctrine of declaring that the legislative, executive, judicial powers ought to be kept in a separate form, and independent of each other as the nature of a free government will admit, or it is constitute, which that the chain of connection that binds the whole fabric of the Constitution in one indissoluble bond of unity and amity. Her Constitution accordingly mixes these departments in several respects. The Senate, which is a branch of the legislative department, is also the judicial tribunal for the trial of impeachments. The President, who is the head of the executive department, is the presiding member also of the Senate, and besides in equal votes in all cases, has a casting vote in the case of a tie. The executive head is itself eventually elective every year by the legislative department and his council, and every year chosen from the members of the same department. So he's saying that the separation is a secondary importance to the balancing between them. Several of the officers of state are also appointed by the legislature, and the members of the judiciary department are appointed by the executive department. The Constitution of Massachusetts observed a sufficient, though less pointed, caution in expressing this fundamental article of liberty. It declares that the legislative department shall never exercise the executive and judicial powers, or either of them, the executive shall never exercise the legislative and judicial powers, or either of them, the judicial shall never exercise the and executive powers, or either of them. This declaration corresponds precisely with the doctrine of Montesquieu. As it has been explained, it is not a single point violated by the plan of the convention. It goes no farther than to prohibit any one of the entire departments from exercising the powers of another department. In this very Constitution, to which it is prefixed, a partial mixture of powers has been admitted. The executive magistrate has qualified negative on the legislative body, and the Senate, which it is a part of the legislature, is a court of impeachment for members of the executive and judicial departments. The members of the judicial departments, again, are appointed by the executive department and ruled by the same authority of address of the two legislative branches. Okay, so the separation of powers doesn't mean separate branches. It means like they all have a control over each other. Lastly, a number of officers of government are annually appointed by the legislative department. As the appointments to officers, particular executive officers, is in the nature of the executive function. The compilers of the Constitution have, in the last point at least, violated the rule established by themselves. I pass over the constitutions of Rhode Island and Connecticut because they were formed prior to the Revolution, and even before the principle under examination had become an object of political attention. The Constitution of New York contains no declaration on this subject, but appears very clearly to have been framed with an eye to the danger of improperly blending the different departments. It gives, nevertheless, the executive magistrate a partial control over the legislative department, and what is more, gives light control of the judiciary department, and even blends the executive and judiciary departments in the exercise of this control. In its council of appointment members of the legislature are associated with the executive authority. In this appointment of officers, both executive and judiciary, and its courts for the trial of impeachments and the correction of errors, is to consist of one branch of the legislative and the principal members of the judiciary departments. The Constitution of New Jersey has blended the different powers of government more than any other the preceding. The governor, who is the executive magistrate, is appointed by the legislature. Its chancellor and ordinary are surrogate of the state, is a member of the Supreme Court of Appeals. The president, with the casting votes of one of the legislative branches, the same legislative branch acts again in the executive council of the governor, and with the constituents of the Court of Appeals. So he's going to give a lot of these examples, it looks like, of the different state constitutions, going over how they do this, the separation of powers, and that it is important, but they're all not perfect, and there's a reason for this. The members of the judiciary department are appointed by the legislative departments and removable by one branch of it on the impeachment of the order. According to the Constitution of Pennsylvania, all right, let's get through these fast. The president, who is the head of the executive department, is annually elected by one vote in which the legislative department predominates. In conjunction with the elective council, he has appointed the members of the judiciary department and formed a court of impeachment for trials of all officers, judiciary as well as executive. The judges of the Supreme Court or justices on the peace also seem removable by the legislature, and the executive power of pardoning in certain cases to be referred by the same department. The members of the executive council are made ex officio justices of the peace throughout the state. In Delaware, the chief executive magistrate is annually elected by the legislative department. The speakers of the two legislative branches are the vice presidents in the executive department. The executive chiefs, with 6 others appointed by each of the 3 legislative branches, consider the Supreme Court of Appeals. He is joined by the legislative department in the appointment of these other judges. Throughout the states, it appears that the members of the legislature may at the same time be justices of the peace. In this state, the members of one branch are in the ex officio justices of the peace, as are the members of the executive council. The principal officers of the executive department are appointed by the legislature, and the one branch of the latter forms the court of impeachments. All officers may be removed by the address of the legislature. Maryland has adopted the maxim of the most unqualified terms. I was going for another example. Executive and judicial powers of the government ought to be forever separate and distinct from each other. Her Constitution, notwithstanding, makes the executive magistrate appointed by the legislative department and the members of the judiciary by the executive department. The language of Virginia is still more pointed to the subject. Her Constitution declares that the legislative, executive, judiciary departments shall be separate and distinct, and that neither exercise the powers that properly belongs to the other, nor shall any person exercise the powers more than one of them at the same time, except that the justices of the county courts shall be eligible to either house or assembly. Yet we find that only this expresses express exception with respect to the members of the inferior courts, but the chief magistrate with the executive council are appointed by the legislator. That the two members of the latter are triennially displaced by the pleasure of the legislator, and that all principal officials, executive, judiciary, are favored by the same department. The executive prerogative of pardon also, in the case of vestigial education department, the Constitution of North Carolina, which declares that the legislative, executive, supreme judicial powers of the government ought to be forever separate and distinct from each other, refers to at the same time to the legislative department, appointed not only by the chief executive, but all principal officers within both the judiciary department and the... Okay, this feels like the part, like, in the Bible where they just, like, go over, like, oh, he was the father of this guy, and he was the father of that guy, and he was the father of that guy. But he was making a point. He's like going, look, all these people complaining about the mixing of the branches is like that we all want separation of powers. Look, every single state has some sort of mixing, some kind of checks on each other, some kind of, like, this branch kind of melds into this branch in this way. It's like you're going to have these edge cases to have a functioning government, while not giving up the importance of the separation of powers. All right. It gives to the latter also the appointments of the... Okay. Oh my God, he's going on. In the Constitution of Georgia, where it is declared that the legislative, executive, judiciary departments shall be separate and distinct, so that neither exercise the powers properly belong to the other, we find that the executive department is to be filled by appointments of the legislator, and the executive prerogative of pardon to be finally exercised by the same authority. Even justices of the peace are to be appointed by the legislator. In citing these cases in which the legislative, executive, and judiciary departments have been kept totally separate and distinct, I wish not to be regarded as an advocate for the particular organizers of the several state governments. I am fully aware that among the excellent principles which they exemplify, they carry strong marks of the haste, and still stronger of the inexperience, under which they were framed. But it is too obvious that in some instances that the fundamental principle under consideration has been violated by too great a mixture, even an actual consolidation of the different powers, and then in no instance has a complete provision been made for maintaining in practice the separate delineated on paper. What I have wished to evidence is that the change brought against the proposed constitution of violating the sacred maximum of free government is warranted neither by the real meaning annexed to that maximum by its author, nor by the sense in which it has hitherto been understood in America. The interesting subject will be resumed in the ensuing paper. Publius. That one was hard. Madison loves big, chunky paragraphs. All right, but I think we can go easily on to 48. Still going over what he went in the last one. That, separation of powers. Big, important. Constitution does it as good as humanly possible. These departments should be so far separated as to have no constitutional control over each other. James Madison, 78, in a pamphlet posted in New York. It was shown in the last paper that the political apocathym their examinations does not require that the legislative, executive, and judiciary departments should be wholly unconnected with each other. I shall undertake, in the next place, to show that unless these departments be so far connected and blended as to give a constitutional control over the others, the degree of separation which the maxim requires, and essential to free government, can never be in practice be dully maintained. It is agreed on all sides that the powers properly belonging to one of the departments ought not be directed to completely administered by either of the other department. It is equally evident that none of them ought to possess, directly or indirectly, an overruling influence over the others. In administration of their respective powers, it will not be denied that power is one of the encroaching nature, and that it ought to be effectively restrained from passing the limits assigned to it. After discriminating, therefore, in theory, the several classes of power as may be in their nature be legislative, executive, or judiciary. The next and most difficult task is to provide some practical security for each against the invasion of the others. What the security ought to be is the great problem to be solved. Will it be sufficient to mark with precision the boundaries of these departments in the constitution of the government, and to trust these parchment bearers against the encroaching spirit of power? This is the security which appears to have been principally relied by the compilers of most American constitutions. But experience assures us the efficacy of the provision has been greatly overrated, and that some adequate defense is indispensably necessary for more feeble against the more powerful members of the government. The legislative department everywhere extending the sphere of its activity and drawing all power into its impetuous vortex. The founders of our republics have so much merit for the wisdom which they have displayed, that no task can be less pleasing than that of pointing out the errors into which they have fallen. The respect for truth, however, obliges us to remark that they seem never for a moment to have turned their eyes from the danger to liberty, from the overgrown and over-grasping prerogative of a hereditary magistrate, supported and fortified by a hereditary branch of the legislative authority. They seem to never have recollected the danger from legislative usurpations, by which assembling all power in the same hands must lead to the same tyranny as threatened by the executive usurpations. In a government where numerous and extensive prerogatives are placed in the hands of a hereditary monarch, the executive department is very justly regarded as the source of danger, and watched with all the jealousy which the zeal for liberty ought to inspire. In a democracy where a multitude of people exercise in person the legislative functions, and continually exposed by their incapacity for regular deliberation and connected measures to the ambitions of intrigues of their executive magistrates, tyranny may well be apprehended on some favorable emergency to start up in the same quarter. But in a representative republic, where the executive magistrate is carefully limited both to the extent and duration of its power, and where the legislative power is exercised by an assembly which is inspired by the supposed influence over the people, with an intrepid confidence in its own strength, which is sufficiently numerous to feel all passions which a multitude, yet not so numerous as to be incapable of pursuing the objects of its passions, by means which reason prescribes. It is against the enterprising ambition of this department that the people ought to indulge all their jealousy and exhaust all their precautions. The legislative department derives a superiority in our governments from other circumstances. Its constitutional powers, being at once more extensive and less susceptible to precise limits, can with great facility mask, under the complicated and indirect measures, the encroachments in which make on the coordinate departments. It is not unfrequently that a question of real nicety in legislative bodies, whether the operation of a particular measure will or will not extend beyond the legislative sphere. On the other hand, the executive power being restrained within a narrow compass and being more simple in its nature, and the judiciary being described by landmarks still less uncertain, projects a usurpation by either of these departments, would immediately betray and defeat themselves. Nor is this all, as the legislative department alone has access to the pockets of the people. This was very important. The power of the purse. The legislative department had the money, and this was very, very important to the Founding Fathers. And it is really sad when that is violated. And has in some constitutions full discretion and an all-prevailing influence over the pecuniary reward on those who fill other departments. A dependence is thus created in the latter, which gives still greater facility to encroachments on the former. I have appealed to our own experience for the truth of what I advance this subject. Were it necessary to verify this experience of particular proofs, they might be multiplied without end. I might find a witness in every citizen who has shared in or been attended to the course of public administrations. I might collect vouchers in abundance from the records and archives of every state in the Union, but as a more concise and at the same time equally satisfactory evidence, I will refer to the examples of two states, attested to by two unexceptional authorities. The first example is of Virginia, a state which has seen and expressly declared in its constitution that three great departments ought not to be intermixed. The authority and the subject of it is Mr. Jefferson, who, besides his other advantages for remarking the operations of the government, was himself a chief magistrate of it. In order to convey fully the ideas in which the experience has impressed him on the subject, it will be necessary to quote a passage of some length from the very interesting Notes on the State of Virginia, page 195. Quote, all powers of government, legislative, executive, and judiciary result to the legislative body. The concentrating these in the same hands is precisely the definition of despotic government. It will be no alleviation that these powers would be exercised by a plurality of hands and not by a single one. 173 despots would surely be as oppressive as one. Let those who doubt it turn their eyes to the Republic of Venice. As little will avail us as they are the chosen by ourselves, an elective despotism. Was not the government we fought for, but one which should only be founded on free principles, but in which these powers of government should be so divided and balanced among the several bodies of magistrate as to no one could transcend their legal limits without being effectually checked and restrained by the others. That was the Virginia Constitution. For this reason, the convention which passed the ordinance of government laid its foundation on this basis, that the legislative, executive, and judiciary departments should be separate and distinct, so that no person should exercise the powers of more than one of them at the same time. But no barrier was provided between the several powers. The judiciary and executive members were left dependent on the legislative for their subsistence in office, and some of them for their continuance in it. If, therefore, the legislative assumes executive and judiciary powers, no opposition is likely to be made, nor, if made, can be effectual, because in the cases they may put their proceedings into the forms of acts of assembly, which would render them obligatory on the other branches. They have accordingly, in many instances, decided rights which should have been left to the judiciary controversy and the direction of the executive during the whole time of their session is becoming habitual and familiar. The other state which I shall take an example of is Pennsylvania, and the other authority the Council of Censors, which assembled in the years 1783 and 1784. The part of the duty of this body, as marked out by the Constitution, was to inquire whether the Constitution had been preserved inviolate in every part, or whether the legislative and executive branches of government had performed their duty as guardians of the people, or assumed themselves, or exercised other or greater powers than they are entitled to by the Constitution. In the execution of this trust, the council were necessarily led to a comparison in both legislative and executive proceedings with the constitutional powers of these departments, and from the facts enumerated, and the truth of most of which both sides in the council subscribed, it appeared that the Constitution had been fragrant out in the open violated by the legislator in a variety of important instances. A great number of laws have been passed, violating without the apparent necessity the rule requiring that all bills of a public nature shall be previously printed for the consideration of the people, although this was one of the precautions chiefly relied on by the Constitution against improper acts of the legislator. The constitutional trial by jury had been violated, and the powers assumed by which had not been delegated by the Constitution. Executive powers had been usurped. The salary of judges, which the Constitution expressly required to be fixed, had been occasionally varied, and in cases belonging to the Judiciary Department, frequently drawn within the legislative cognizance and determination. Those who wish to see the several particulars falling under each other of these heads may consult the journals of the council which are in print. Some of them will be found may be imputable to a particular circumstance connected with the war, but the great part of them may be considered as the spontaneous shots of an ill-constituted government. It appears also that the executive department had not been innocent of frequent breaches of the Constitution. There are 3 observations, however, which ought to be made on its head. First, a great proportion of instances were either immediately produced by the necessity of the war or recommended by Congress or the commander-in-chief. Secondly, in most of the other instances, they conformed either to the declaration of the known sentiments of the legislative department. Thirdly, the executive department of Pennsylvania is distinguished from that of the other states by the number of members composing it. In this respect, it has as many affinity to the legislative assembly as to an executive council. And being once exempt from the restraint of individual responsibility for the acts of the body, and deriving confidence from the mutual example of the joint influence, unauthorized measures would, of course, be more freely hazarded than when the executive department is administered by a single hand, or by a few hands. Finally, the conclusion which I am warranted is drawing from these observations is that mere demarcation on parchment of the constitutional limits of the civil department is not sufficient. It's not a guard against the encroachments of which lead to tyrannical concentration of powers of government in the same hands. And that's how he ends it, which is actually a little terrifying. That's how he ends it, which is actually a little terrifying. All right. I think he's going to... All right, we're still on separation of powers. We're going on to number 49. All right. I think he's going to... All right, we're still on separation of powers. We're going on to number 49. Method of guarding against the encroachments of any one department of government, appealing to the people throughout the convention. I'm glad he got into this, and now he's getting onto this one, because his last one was a real bummer. It was like, it's going to happen. Look how bad it is. All right, Hamilton or James Madison. Oh, I guess they weren't able to tell. All right, I can tell. It's going to happen. Look how bad it is. That's Madison. All right. Whenever you see a paragraph this long, it's Madison. It's every time, without fail. Only Madison writes in giant, long, run-on paragraphs. Although, okay, Hamilton will do too. The author of the Notes on the State of Virginia, quoted in the last paper, has subjoined to the valuable work of the draught of the Constitution, which has been prepared in order to be laid before the Convention, expected to be called in 1783, by the legislature for the establishment of the Constitution for the Commonwealth. The plan, like everything from the same pen, marks a turn of thinking, original, comprehensive, and accurate, and the more worthy of attention that is equally displayed a fervent attachment to a republican government and an enlightened view of the dangerous propensities against which it ought to be guarded. One of the precautions which he proposes, and on which he appears ultimately to rely on a palladium to the weaker departments of power against invasion of the stronger, is perhaps altogether his own, and it is immediately relates to the subject of our present inquiry. Ought not to be overlooked. His proposition is that whatever any two of the 3 branches of government shall concur in opinion, each by the voices of the 2/3 of their whole number, and that a convention of necessary for altering the Constitution, or by correcting breaches of it, a convention shall be called on for its purpose. As the people are the only legitimate fountain of power, and it is from that constitutional charter under which the several branches of government hold their power is derived, it seems strictly cognizant to a republican theory to recur the same original authority, not only whenever it may be necessary to enlarge, diminish, or new model the powers of government, but also whenever any one of the departments may commit encroachments on the chartered authorities of the others, the several departments being perfectly coordinate by the terms of their common commission. None of them, it is evident, can be pretended to an exclusive or superior right of settling the boundaries between their respective powers. And how are the encroachments of the stronger to be prevented, or the wrongs of the weaker to be redressed, without an appeal to the people themselves, who, as the grantors of the commission, can only declare the true meaning and enforcers of observance? There is a certainly great force to be reasoning, and it must be allowed to prove the constitutional road to the decision of the people ought to be marked out and kept open. For certain great and extraordinary occasions there appear to be insuperable objections against the proposed concurrence to the people, as the provision in all cases for keeping the several departments in power within their constitutional limits. In the first place, the provision does not reach the case of combination of the two of the departments against the third. If the legislative authority, which possesses so many means of operating on the motives of the other departments, should be able to gain in its interest either of the others or even one-third of its members, the remaining department should derive no advantage from the redeemable provision. I do not dwell, however, on this objection, because it may be thought to be rather against the modification of the principle than against the principle itself. In the next place, it may be considered as an objection inherent to the principle that every appeal to the people would carry the implication of some defect of the government. Frequent appeals would, in great measure, deprive the government of veneration from which bestows on everything, and without the perhaps the wisest and free of governments would not possess the requisite stability. If it were to be true that all governments rest on opinion, it is no less true that the strength of opinion in each individual and the practical influence on his conduct depends much on the number which he supposes to have entertained of the same opinion. The reasons of man, like man himself, is timid and cautious when left alone, and acquires firmness and confidence in proportion to the number which it is associated. When the examples which fortify opinion are ancient as well as numerous, they are known to have double effect. In a nation of philosophers, this consideration ought to be disregarded. A reverence for the laws would be sufficiently inculcated by the voice of the enlightened reason. But a nation of philosophers is little to be expected as the philosopher race of kings wished for by Plato, and in every other nation. The most rational government will not find a superfluous advantage to have prejudices of the community on its side. The danger of disturbing the public tranquillity by interesting too strongly the public passions is a still more serious objection against the frequent references of constitutional questions to the decision of the whole society. Notwithstanding the success which has attended the revisions of our established forms of government, which does so much honor to the virtue and intelligence of the people of America, it must be confessed that with the experiments are too ticklish. Ticklish? Does he really say ticklish? A nature to be unnecessarily multiplied. We are to recollect that all existing constitutions were formed in the midst of danger, which would repress the passions most unfriendly to the order and concord, of enthusiastic confidence of the people in their patriotic leaders, which stifled the ordinary diversity of opinions on great national questions. If a universe ardor for new opposite forms produced by universal resentment, and indignation against the ancient government, and whilst no spirit of party connected with the changes to be made, or the abuses to be reformed, could mingle its leaven in the operation, the future situations in which we must expect to be usually placed do not present any equivalent security against the danger which is apprehended. But the greatest objection of this is that the decisions which would be probably result from such appeals would not answer the purpose of maintaining the constitutional equilibrium of the government. We have seen that the tendency of republican governments is to aggrandizement of the legislative at the expense of the other department. The appeals to the people, therefore, would usually be made by the executive and judiciary departments. But whether made by one side or the other, would each side enjoy equal advantages on the trial? Let us view their different situations. The members of the executive and judiciary departments are few in number and can personally be known to a small part only of the people. The latter, by the mode of their appointment as well as the nature and permanency of it, are too far removed from the people to share much of their prepossessions. The former are generally the objects of jealousy, and their administration is always liable to be discolored and rendered unpopular. The members of the legislative department, on the other hand, are numerous. They are distributed and dwell among the people at large. Their connection of blood, friendship, and acquaintance embraces a great proportion and most influential part of society. The nature of their public trust implies a personal influence among the people, and that they are more immediately and the confidential guardians of the rights and liberties of the people. With these advantages, it can be hardly supposed that the adverse parties would have an equal chance for favorable issue. But the legislative party would not only be able to plead their cause most successfully with the people, they would probably be constituted themselves the judges. The same influence which has gained them an election in the legislature would gain them a seat in the convention. If this should not be the case with it all, it would probably be the case in which many, pretty certainly with the leading characters, on whom everything depends on such bodies. The convention, in short, would be composed chiefly of men who were actually expected to be members of the departments whose conduct was arranged. They would consequently be parties to the very question to be decided by them. It might, however, sometimes happen that appeals would be made under circumstances less adverse to the executive and judiciary departments. The usurpations of the legislators might so frequently, so suddenly, as to admit of no specious coloring. A strong party among themselves might side with the other branches. The executive power might be in the hands of a particular favorite of the people. In such postures of things, the public decision might less be swayed by prepossessions of favor of the legislative party. But still, it could never be expected to turn on the true merits of the question. It would inevitably be connected with the spirit of pre-existing parties, or of parties springing out of the question itself. It would be connected with the persons of distinguished character of extensive influence in the community. It would be pronounced by the very men who had been agents in or opponents of the measures to which decisions would relate. The passions, therefore, not the reasons of the public would sit in judgment, but it is the reason alone of the public that ought to control and regulate the government. The passions ought to be controlled and regulated by the government. We found in a last paper that mere declarations in the writing of the Constitution are not sufficient to restrain the several departments within their legal rights. It appeared in this that occasional appeals to the people would be neither a proper nor effectual provision for that purpose. How far the provisions of different nature contained in the plan above quoted might be adequate, I do not examine. Some of them are unquestionably founded on the sound political principles, and all of them are framed with a single ingenuity and precision. Publius. All right. We got 49 down. One more to go for tonight. Oh, it's a short one. Wow. These all have been really short. Madison went on for so long about little details and things, but the separation of powers is a lot more. Suddenly, he's like, "Yeah, I'm gonna write shorter on these." All right, periodic appeals to the people considered. 50. Hamilton or Madison. Oh, all right. This might be. You can always tell a Madison. A lot more caps. There's more caps, but there's shorter paragraphs. I'm not sure. It may be contended, perhaps, that it may be occasional appeals to the people which are liable to the objects urged against them. Periodic appeals are to be proper and adequate means of preventing and correcting infractions of the Constitution. It will be attended to that the examination of these expedients, I confirm myself to their aptitude for enforcing the Constitution, by keeping several departments of power within their due bounds, without particularly considering them as provisions for altering the Constitution itself. In the first view, appeals to the people at fixed periods appear to be nearly as ineligible as appeals to particular occasions as they emerge. If the periods be separated by short intervals, the measures to be reviewed and rectified will have been of a recent date, and will be connected with all circumstances which tend to violate and pervert the result of occasional revisions. If the periods be distinct from each other, the same remark will be applicable to all recent measures, and the proportion or remoteness of each other's may favor or dispassionate review of them. This advantage is inseparable from the inconveniences which seem to counterbalance it in the first place. A distinct prospect of public censure would be very feeble restraint on power from the excesses in which it might be urged by the force of present motives. It is to be imagined that a legislative assembly consisted of 100 or 200 members eagerly bent on some favorable object and breaking through the restraints of the Constitution in pursuit of it, would be arrested in their careers by considerations drawn from the censorial revision of their conduct at future distance of 10, 15, 20 years. In the next place, the abuse would often be competed with mischief effects before the remedial provisions would be applied. And in this last place, or it might not be the case, they would be of long standing, would have taken deep root, and would not easily be excised. The scheme of revising the Constitution in order to correct recent breaches of it, as well as for other purposes, has been actually tried in one of the states. One of the objects of the Council of Censors, which met in Pennsylvania in 83-84, was, as we have seen, to inquire, quote, whether the Constitution has been violated, whether the legislative and executive departments have encroached on each other, end quote. This important, with the novel experiment in political merits in several points of views, very particular attention. And some of them may perhaps, as a single experiment, made under circumstances somewhat peculiar, be thought not absolutely conclusive, but as applied in the case under consideration. It involves some facts, which I venture to remark as a complete and satisfactory illustration on the reasoning which I have employed. First, it appears from the names of the gentlemen who composed the council that some, at least most, active members have also been active in leading characters in the parties which pre-existed in the state. Secondly, it appears that the same active and leading members of the council have been active and influential members of the legislative and executive branches within the period to be reviewed, and even patrons or opponents of the very measures to be thus brought to the test of the Constitution. Two of the members have been vice presidents of the state, and several other members of the executive council within the 7 preceding years. One of them has been a speaker, and another other distinguished members of the Legislative Assembly within the same period. Thirdly, every page of their preceding witnesses the effect of all circumstances on the temper of their deliberations. Throughout the continuance of this council, it is split into 2 fixed and violent parties. The fact is acknowledged and lamented by themselves. Had not been the case, the face of their proceedings exhibits a proof equally satisfactory. In all questions, however, unimportant to themselves or unconnected to each other, The same names stand invariably contrasted on the opposite columns. Every unbiased observer may infer without danger of mistake and at the same time without meaning to reflect on either party or any individuals of either party that unfortunately passion, not reason, must have been presided over their decision. When men exercise their reason coolly and freely on a variety of distinct questions, they inevitably fall into different opinions of some of them. When they are governed by a common passion, their opinions, it is to so be called, will be the same. Fourthly, the least problematical, whether the decisions of the body do not, in several instances, misconstrue the limits prescribed for the legislative and executive departments, instead of reducing and limiting them without their constitutional places. Fifthly, I have never understood the decisions of the Council on constitutional questions, whether rightly or erroneously formed, have had any effect in varying the practices founded on the legislative construction. It even appears, if I mistake not, that in one instance the contemporary legislator denied the construction of a council, and actually prevailed in the contest. This censorial body, therefore, proves at the same time, by its researches, the extenses of the disease by which its example, the inefficiency of the remedy. This conclusion can be invalidated by alleging that the state in which the experiment was made was at that crisis, and has been for a long time before, violently heated and distracted by a rage of party. It is to be presumed that any future septennial epoch of the same state will be free from parties. It is to be presumed that any other state at the same or of any other given period will be exempt from them. Such an event ought to be neither presumed nor desired, because an extinction of these parties necessarily implies either a universal alarm for the public safety or an absolute extinction of liberty. Were the precaution taken of excluding from the assemblies elected by the people to revise the preceding administration of the government, all persons should have been concerned with their government within the given period, the difficulties would not be obviated. The important task would probably devolve on men who with inferior capacities would in either respect be little better qualified, although they might not have been personally concerned in the administration, and therefore not immediately agents in the measures to be examined. They would probably have been involved in the parties connected with these measures, and have been elected under their auspice. I can't say. Allspice. I'll go with that. Publius. All right, that's 50. We got through 10 tonight. Another big chunk. That just means. Oh God. 35 to go. Still a lot. I will. It is Thanksgiving tomorrow, so I'm not working. So maybe I'll get on tomorrow night if I'm not too full. Hope everyone's good night. If you want to read more historical documents with me, throw me a follow. I do it every Wednesday, sometimes also on Thursday. Hope everyone has a good night. Y'all have a good one. I do it every Wednesday, sometimes also on Thursday. Hope everyone has